All right, guys, thanks for joining tonight. I know it's not a night I normally stream on, but I got some somewhat breaking news and I wanted to get this to you as it is kind of an update to our ongoing saga between ThinkUp and Arcade1up. So I'm not going to rehash the entire prior case. We're going to touch on some of those things. So if you missed that, you want to get updated on what's been going on, there are two videos linked in the description. I recommend you watch those. But in brief summary, ThinkUp sued Arcade1up over breach of contract. They did so in New Jersey. That case was ultimately dismissed for lack of venue. That dismissal occurred earlier this month in August. And I got to say, I am pretty shocked at how quickly ThinkUp moved to refile their case. And this time they did it in the proper venue, which is the Southern District of New York. So, a quick shout out to those who are joining us live. We have, of course, Kevin Clausen, Thumper Squid, Biggie D, Decadent Dave. Thanks everybody for dropping by. And if you have questions as we go through this, go ahead and shout those into the chat. I will try to pay attention as I read key areas of the filing. I'm not, like I said, going to go through everything because most of this is a rehash of the same claims, but there are a few sections that are different. So we'll talk about those. They supplied the same supporting evidence. So again, if you want to see those, which includes some pretty critical information like the actual agreement between ThinkUp and Tastemakers and Disruptive, as well as some emails between Jerry, the CEO of ThinkUp, and Scott Bacharach, as well as some financial accounting for Arcade1up sales for the first 3 quarters of 2023, which gives us some insight into the company's financial position, that being Arcade1up's. So let's just jump right in. And first up, we have, got to get to where I can actually see this. So we have the claim itself, and you can see it was filed up here in the Southern District of New York. And once again, ThinkUp is suing both Disruptive Products Inc. and Tastemakers. Essentially, this just says, here are the parties. This is where they are located. And the first thing may be nitpicky, but I'm going to point it out because, again, as you watch those old cases, or the old case and the old filings, we see that a lot of what ThinkUp did with Tastemakers and Scott Bacharach and these companies was done with handshakes, back of the cocktail napkin type stuff, not actual contracts until 2019. And that's created some confusion on ThinkUp's part. I don't think there's any confusion from anybody else, but we'll get into that. But my point there is the lawyers that are taking this case, right? They filed in New Jersey, even though they knew ThinkUp had filed in New York. That got the case tossed. They are making claims on behalf of ThinkUp that are clearly, in my opinion, not accurate based on the agreement that ThinkUp signed. And so there's some questionable reading of the law and of the contract language there. And so what I want to point out here is number 3, where they are describing Tastemakers. And it says Tastemakers is believed to be a New York limited liability company with a principal place of business at 51 blah, blah, blah in Miami, Florida. Its former CEO during most of the events in this complaint was Scott Bacharach. Quote, right in parentheses, they do this because this is how they're going to refer to him through the rest of the case, Mr. Bacharach. And then this is the interesting part. Right after that, Mr. Blanchard is believed to be the only member of the LLC and is believed to be a citizen of Florida. Who the hell is Mr. Blanchard? Well, Mr. Blanchard is supposed to be Mr. Bacharach. No other place in this entire document is Mr. Blanchard referred to, of, by, or for. It's a typo. It's probably an autocorrect when they mistype something. But again, who proofread this? This is right at the beginning. This is the person you are making claims against, and you screwed his name up right at the beginning. So, if that tells you anything about the representation that we're here. The other thing I want to say, disclaimer up front, it's not legal advice. If you want legal advice, you should contact an attorney. This is for entertainment purposes only. So let's get back into it. So here they stipulate, and this is interesting because now they're basically stipulating that their agreement throughout this lawsuit with Tastemakers and Disruptive, that the agreement is valid. And you'll see why they actually do this on purpose. But it's believed in for, and the proper venue in the court and the defendants are subject to personal jurisdiction with the judicial district and have granted agreements requiring actions to be brought here. So they're referencing that 2019 agreement and say, although every one of these people is not in New York, that they're in, Miami, that they're in, I think, Las Vegas, and one other location, New Jersey, right? So New Jersey, Nevada, and Florida, that the agreement they have in 2019 says it'll be in New York, which is why they're filing the case in New York. So once again, they're saying we have an agreement. That's why we're filing here. So admission that the agreement is valid. And this is where they go, again, the same claims we've talked about. They take credit for all the designs, animations, 3D modelings, yada, yada. We won't go through all that because that would be rehashing. Jerry Cummings is the sole shareholder of ThinkUp. Again, they tell the story of how he's worked with Bacharach through the 1990s, basically until 2022. And that all during that time, they always did handshake deals. They've worked for them, and every deal had a 3% of sales revenue as its compensation. In July 2020, it says Cummings went to Bacharach and told him about this Arcade1up that they've designed. They did a foam core markup, big blocks. Again, this is all rehashed, so I'm going to move through this quickly. So if you want the details of all of these, obviously you can pause and read any of this, or you can go watch that other video because it's we go into that one pretty in deep. Here's that two shook hands and agreed to work together. So again, they're saying they went to Arcade1up or Tastemakers and said, look, we made this, and what do you want? And they liked it, yada, yada. So 3% of net sales for the life of the sales product. We've talked about the issues with that. That was agreed to in an email, but it doesn't say the life of the product anywhere in that email. It just says for the life. And when you don't define it like that, it's left up to interpretation. What if Tastemakers believed it was for the life of the sales or their agreement, while ThinkUp said it's the life of the product? So it's all over the place and it's not defined, which leaves it ambiguous, and which is kind of why they're seeking court relief to help them define that. But as we've talked about previously, their agreement washes away anything that they previously had agreed, handshake, writing, or otherwise, and they signed that agreement. So all that prior agreement that they're trying to reference is all a wash. It's all gone. But they are using it to try to explain their position in this case. And again, we'll get into that. They talk about their costs, where they invested all this stuff. They talk about where they created the brand. Interestingly, as we get in here, this is the logos and yada, yada. They only claim to have created the shark fin design as part of the design. And they reference it here. I think it was up here somewhere. It talks about how they traveled to Hong Kong and China. So here it is, but not limited to the unique sharp fin shape, which they took credit for, claiming that was unique and that was their design. The 3/4 scale designed to better suit home use so that children could stand up, could play at them standing up, and then ThinkUp also designed a riser to allow the unit to rise to fit a standing adult. So that's interesting that they limit their design of the Arcade1up product to that. Makes me wonder if were they actually the people that designed the other cabs, right? Did they design the deluxes? Um, it's not real clear. I mean, they don't make that claim anywhere on here. So, of course, they did give themselves an out, but said not limited to, and maybe they're just referencing the big ones as part of their case. But it does seem odd. You would think they would make the claim that they've basically designed them all up until now. But anyway, they worked with manufacturers to design and print the PCBAs. Um, at this time, you're saying basically Tastemakers had no employees. That the claim is that basically it was Scott Bacharach. So this is a little more information than we had before. It's potentially this is when maybe John D came into the company and said maybe there were two employees, but their perception, ThinkUp's perception at this time was basically that it was Scott and nobody else. Um, Talks about they created the logos again, all the same stuff. Traveled to Hong Kong, yada yada yada, threefold. First, it was this is again explains the role of Tastemakers, that it was to secure the licenses for the games that they produced, and then they were also to secure financing from for the manufacturing process, and third, it was to secure wholesale customers for the Arcade1up machines. That left design, finding manufacturers, marketing, um, material designs, whether that's signage, advertisements, instruction manuals, yada, yada, yada. That was all left up to ThinkUp. So Tastemaker's role was very narrowly defined. And for that, ThinkUp, it was supposed to be paid, 3%. Again, they talk about the end of 2017. Mr. Bacharach announces that they sold 100,000 machines to Walmart and that Walmart gave them a letter of credit in order to go start the manufacturing process. So I've heard some discrepancy about the timing of this. This is what ThinkUp alleges, is that they designed it first. They went to Scott. Scott then went and sold it to Walmart and got the funding from Walmart. During this time, Mr. Cumming believes Tastemakers had almost no employees other than Mr. Bacharach. And in February 2018, the handshake agreement between Tastemakers and ThinkUp. And how you doing, Brooklyn? Just going to quickly skim through here to see if there is any big questions yet so far. I'm trying to go a little quickly. It says, frivolous lawsuit case dismissed again. Did it occur to anyone that maybe the reason Scott and John left one up is because the lawsuit was coming? So if they are gone, so I don't think they knew that the appreciate the comment, stupid fat hobbit. At the time they left, it was before they Arcade1up severed ties with ThinkUp. This lawsuit came after Arcade1up, Dora DeVere, and the COO, I'm drawing a blank on his name off the top of my head, basically wanted to negotiate the contract with ThinkUp, and then ThinkUp wasn't into restructuring that, and so Arcade1up canceled the contract on them, terminated it under terms in their agreement that would allow them to do it. So they followed the agreement and provided him notice, and then provided him a final accounting of sales for the year, which is how we got the sales numbers as part of that notice. Anyway, so we won't rehash again the all this stuff. They do note that the first time they were ever paid by Arcade1up. So up to this point, ThinkUp never received a dime. And then in February 2019, Arcade1up received the prestigious Toy of the Year award at the New York Toy Fair, which everybody knows that's the huge toy fair. Just before the announcement of the award, Mr. Bacharach handed Mr. Cummings a $500,000 Tastemakers check without any accompanying report. This was the first monies that ThinkUp received for its work from Arcade1up. So you can see basically for over a year, Tastemakers didn't pay ThinkUp a dime. But when they finally did, they cut him a check for $500,000, but there's no auditing to go with it. I'll point out that in that agreement, there is no requirement stipulated that Disruptive or Tastemakers would provide an auditing of sales. Um, Normally, you would make sure you have that authority in your contract, but they did not do that. And for those that don't remember, that's because Jerry at ThinkUp didn't really understand the language, asked Scott if it was good, and Scott said yes, and so he signed it. So he did not have a lawyer review it. So again, always have a lawyer review anything you're signing. It's worth the money, trust me, um, as ThinkUp is finding out. Um, uh, this is this is when they get the handwritten agree or they start the agreement. They now have an investor wants all agreements in writing, so they come up with the 2019 agreement, and in that 29 agreement it has language that stipulates it overrides any prior agreement, written or otherwise. So this leaves ThinkUp in a bad position. um, Blah blah blah, we'll just get through this. It says they don't know the company, they're talking about the different games, um, consoles, license, including but not limited to cabinetry, interface controls, blah, blah, blah. Arcade1up name and logo. Tastemakers would secure the license. So they're just reiterating what they've already said. They're saying it's part of the agreement. So here we go. This is where it gets interesting, and they have some creative interpretation. So we've talked about this paragraph before, but here they're dicing it. So this is where we actually get new claims, or rather a modified claim from ThinkUp, based on what I believe is the argument made to dismiss the case in New Jersey. So they've learned from what Arcade1up's response was and then adjusted their claim a little bit, and it's a little far-fetched, but we'll see. It says the agreement provides in Section B commissions during the term of this agreement and as compensation for all services provided by developer being ThinkUp. Hereunder, company agrees to pay developer 3% of worldwide net sales as hereinafter defined, made, shipped, and distributed to customers on order, which have been approved by company, which have been obtained by developer. This paragraph was relatively consistent with the oral agreement between the parties of 3% royalties for life. So that's the email I was referring to. The use of the word commissions instead of royalties suggests either parties believe they were synonymous or simply that the change made may have been an inadvertent error. Again, I wonder if their attorney even read the agreement, because the word commission flat out says in the contract that they're headings only and should not be interpreted as legal language. So being nitpicky about the word commission versus royalty here is just a waste of breath. It actually flat out says in that commission doesn't actually mean anything. It's just a heading to divide up the contract to find things more legibly. That's it. The language of that paragraph itself doesn't say commissions at all. It just sets out what the fee is. So call it a royalty, call it a commission, whatever. And I think they're doing this because they're trying to head off Arcade1up arguing that ThinkUp was an employee of Arcade1up as opposed to a contractor, which it's possible they could make that claim. Anybody can make that claim. It would just be very hard to prove, given they have an agreement here that's clearly not an employer-employee contract. It's a work contract, right? So, like, meaning to produce products for them. It's not a hiring contract, an employment contract. ThinkUp considered these payment royalties, and the royalties are not tied to an employment arrangement, but survive throughout the life of the creator or even beyond. So again, they're saying this is our royalty agreement and not an employment agreement. However, so we'll get into it, there's severability in the contract that they signed that would stop the royalties and make them not go forever, because nowhere in the contract does it say the royalties go for life. It says the royalties go until 60 days after the agreement's terminated. Paragraph 6A of the 2019 Arcade1up agreement confirms permanency of the royalties. So this is where we're getting our creative interpretation. It provides, at termination, ThinkUp will continue to receive commissions on all Arcade1up machines which have been completed. However, it will not be entitled to commissions on machines that are in development stage and not completed at the time of termination. Thus, royalties for a game like Pac-Man would continue after termination because that model, Arcade1up, was fully developed and complete. The only Arcade1up royalties which would not are games still in the development process and not yet released of the time of termination. So they're saying 6A basically says, hey, we get royalties forever, but if we had something in halfway through the development, we don't get royalties on that if you end up bringing it to market because it was never finished and you completed it or whatever. Except now they go here and they're trying to argue that the provision, section 6D, so that first one was 6A, right? So all part of paragraph 6, so they're all related. So D says developer shall be entitled to commissions in accordance with the provisions of this agreement on orders written up to the effective date of termination or expiration, commission minus termination period, or such other length of time as agreed in writing by the company and developer. All such commissions on orders shipped within 60 days of order date shall be considered earned in accordance with the foregoing and shall be paid in accordance with the provisions set forth below. So this paragraph, the subparagraph, modifies subparagraph A to say your commissions are only while your agreement is with us, and then 60 days after that. So any sale that would occur after or ship, and it has to be shipped right within that 60-day window, you're not entitled to any royalties. And so ThinkUp's argument here is that I think they're trying to go back to that email and say, no, the other agreed in writing by the company includes that email that says we get royalties for life. However, this contract, this agreement between ThinkUp and Disruptive Product Inc. and Tastemakers specifically says it negates all other written agreements or otherwise. So, sorry, you don't have a case there, in my opinion. So they're likely to lose on this claim. But this isn't the only claim they have. And this is what I think they actually have a chance. And it would be good for us because I do think they have a valid argument coming up that if this case makes it to discovery, and I suspect based on the way that this suit is written today, is very likely to make it to discovery. And if it does, we may see Arcade1up have to open their entire books as part of this case, at least up through that termination date. But even beyond that, if this claim is allowed to go forward, the claims in 29. So what this, to continue on this claim, it says what this paragraph does not say is significant. First, it does not say that the developer will not receive royalties or commissions for sales of Arcade1up machines after termination. It does. It does not use any limiting phrase such as only up to. Moreover, at best, the inconsistency of this paragraph, though cited above, creates ambiguity that can only be resolved by admission of the prior written and oral statements providing for royalties. So they're trying to squeeze that email in under this, saying there's no ambiguity. But I think it's pretty clear. It says, as the length of time as agreed in writing by company and developer, all such commissions on orders shipped within 60 days of order date will be considered earned in accordance with the foregoing and shall be paid in accordance with the provision, which would imply that you're not getting paid on anything else outside of that. But maybe there's an argument there to say it doesn't specifically stipulate it, but that's not the rule, right? It has to be, this is a civil lawsuit. So the preponderance of evidence standard applies, which means is it more likely to have occurred that didn't occur? And in this case, clearly the contract language is pretty clearly written that I think your average person is going to think, yes, you agreed to this. It does terminate, but we'll see. A judge can rule any way he wants. Who knows? It says neither Mr. Bacharach nor any other representative defendants ever explained. So this is where he's making these claims that we don't even know who Disruptive Inc. is, but Disruptive Products Inc. is, but they signed the contract. So, uh, come on, don't be silly. You obviously knew something. You signed the contract with them. And then you got payments under that contract from ThinkUp, so you know what their relationship, or sorry, from Tastemakers, so you know there was a relationship there, whether you want to admit it or not. It's clear you did. For this reason, ThinkUp needs accurate. Yeah, so here we go. So this is the next thing. This is where they've kind of rehashed a little bit what they've said before, but now they're making a better claim about it, in my opinion. So it says it's unclear what revenues were of the sales of Arcade1up machines to Walmart, Best Buy, Target in the years that followed the execution of the 2019 Arcade1up agreement. Remember, they were just paid for the first time at the beginning of 2019, and I think this agreement was signed February, around the same time, because ThinkUp was provided inadequate reports of such sales. According to the conversations Mr. Cummings had with Tastemakers employees, as well as Mr. Bacharach, ThinkUp believes the total revenues may have been in the range of $500 to $750 million, which should have generated royalties to ThinkUp of more than $20 million, yet ThinkUp received little more than half that amount. So, again, we've seen this specific claim before, but now that they've kind of reworded things a bit, what they're saying is they're not sure because Arcade1up never gave them any accounting of what sales were. What ThinkUp is looking for is how many Pac-Mans did you sell? How many Street Fighter 2s were sold? How many Trons were sold and at what amounts? What was the actual number and amount of revenue from each cab sold? And without that breakdown, their claim is they have no way to know if Arcade1up upheld their end of the agreement. That to me is even though they didn't have auditing in there, that's a pretty valid claim. They could argue like that information was withheld. Hope they've made requests for that information and that they can show emails or letters or anything to show that they've requested that accounting in the past and just not been given it, because it's going to be tough for them to go back and say, hey, it's 5 years later, now we want an accounting. But it is legitimate. Like, how do they verify that they were paid out correctly under the agreement? They have no information to go on. And so this is where I think they actually have something. I think this will and this is really kind of the rest of it. It goes into the Infinity Game Board. We talked about that in the past. There's nothing new through the rest of this. This is the claim of how they should be paid for the Infinity Game Board, the 3% there, the Infinity Game Table, 3% on the hardware, and then 30% on all software royalties, 70% on the ones, the 38 games they developed themselves. So it's just rehashing the same stuff that they said they developed all of that. So we're going through all this. So, like I said, all of this is the exact same from the existing lawsuit. Nothing big or different there. So again, if you want to see that, go check out that other video. Let's see here. These are all the royalties, copies of the letters, blah, blah, blah. Okay, so here's what they want. They want an accounting. So they're entitled to an accounting of all revenues of Tastemakers and Disruptive of Arcade1up Infinity Game machines from 2018 to present. This is where I think again, this is where they have a case. They have an argument. They could be owed money because they have no way to validate whether they've been paid accurately. And if their assumption on sales is correct and Arcade1up owes them $10 million, that could be the case. I mean, that really could be reality. Now, we'll find out, because if this goes to discovery, Arcade1up is going to have to produce that information. Now, they can request to have it sealed because it could be deemed, information that is, intellectual property. It could be, corporate secrets. I'm drawing a blank on the term off the top of my head. but basically, a court may grant them some of that. But in general, typically this stuff doesn't get sealed. So I would be surprised if the judge seals it, but it could happen. So that's something I will be looking out for, right? If we get to discovery and they have to produce this information, we will definitely want to take a look at that. While plaintiff has received some royalty payments for the sale of such machines, the payments were not accompanied by adequate reports of such sales. Plaintiffs believe a review and analysis of such reports will reflect that the defendants owe plaintiff millions of dollars in royalty payments up to the date prescribed in the 2019 Arcade1up agreement and millions of dollars subsequent to that date. So the latter part of this claim, the subsequent millions of dollars subsequent to that date, uh, you know, uh, yeah, maybe the date of the 2019 agreement, but once the agreement was terminated, they're not really entitled to anything other than those sales that were shipped within 60 days. So this is where they go into the breach of contract, where they're alleging you owe us all this royalties for the rest of the life of these arcades, so you better pay up. This is the claim I don't think has any validity, but we'll see. They're asking for damages, and this kind of reiterating those same claims, but now this is specifically about the Infinity game table and the software they developed. And so that's what they're asking for. Those three things. They want a full accounting, and they want to be paid for any get back on screen here. They want to be paid for any royalties that they were owed under the agreement that they haven't received, which I think is a legit question. Then they want to be paid for royalties beyond the agreement, which I don't think really holds any water, but we'll see how the judge rules on that. And that includes monies for both Arcade1up and the Infinity game line of products. And then they want interest both before and after the dates. They want attorney's fees they've asked for. And I think they just want other damages, right, for their, anguish. But so that's my thoughts. I think we might have something interesting here on the accounting, so we'll have to see how that goes. Kevin Clausen says, $4.99 per cab. You can buy 1.5 million golden tees with 750 million. Yes, and we know, Kevin, that Arcade1up has sold somewhere in the range of 4 million cabs, right? Somewhere over 4 million. They've made that claim. It's interesting. So one of the things their attorneys do point out in this is they cover the press releases that we've reported on this channel in the past, right? Arcade1up has issued press releases about sales of those 4 million cabs. They've done press releases on being the number 4 arcade manufacturer in the world, or in the country. I don't know about the world, but definitely in the United States, up there with Sony, Microsoft, and Nintendo. So it's pretty crazy that they didn't mention those before, but now they did. So, maybe they actually did some homework, or maybe they watched a video or two. Who knows? How come you're not wearing a suit like that politician that you are? Good question. Says Mr. James hates everything is leading in the polls. Appreciate the support, guys. Don't forget to make Arcade1up great again. Look for that campaign merch coming soon. Not that you need any merch. I'll probably give a bunch away, but you can definitely download some art and stuff like that you want to represent, off of those things. And obviously, hashtag make Arcade1up great again. Post it everywhere. Get loud. Says, is this a class action, Kevin? It is not. It is just between ThinkUp and Arcade1up. Would be funny if it was, but I don't know what we could sue about. Arcade1up will send you a check with $1.50. 4 million is a big number. Yeah, it's a huge number, right? It's huge. And that number is, I believe, a couple years old at this point. I think they were at 4 million in 2022. So who knows what they've added since then. Obviously, they've gotten uh, more expensive over time. So that's probably reduced the number they sell. But at the same time, they're getting a much higher dollar amount. And keep in mind, they don't get $500 from a $500 cab. They're probably getting 250 or 200 even, because then you've got the distributors that are paying 250 to 300. They get their money, and then the retailers make the difference there. So Arcade1up gets about half of that, I would say, or probably less than half, maybe 40% if they're lucky. Um, which is why it's more beneficial to sell direct because they'll get more money. But hey, that's just me. I'd think it says I'd sue them just so they have to pay a lawyer. Well, I did hear one Arcade1up YouTuber, one who claims to be the number one arcade YouTuber out there. I believe he did file a lawsuit against Arcade1up, and that case got booted like a hot potato because dismissed with prejudice because he had no standing, and why would he have standing? It would be funny because his big lawsuit. If Arcade1up was vindictive, they could have turned that around on, but they didn't. So he should consider himself fortunate on that because they could have made life expensive for him if they really wanted to. Appreciate that, Zero. Obviously, this is the official campaign slogan of the James Hates Everything for president and CEO of Arcade1up. So saved by Zero, and most of that is giant joysticks. 100%. They sold 3.9 million giant joysticks, and all the rest were the other stuff. Robot Ron said, "Is this lawsuit about them not releasing Roboton 2084 by now?" Certainly could be. Oh yeah, that guy, laugh out loud. I heard he lost. He did lose. He got booted out of court summarily. Needless to say, he hasn't updated anybody about the status of that lawsuit. It says, listen to Zero. That is good merch to sell. So I don't know if I could get away with selling this. It does have Arcade1up's logo or ThinkUp's logo. Clearly, ThinkUp is litigious. But doesn't mean we can't do it without the logo and change it just a little bit. And I wonder if how much of this logo they can even copyright or trademark, because this one-up is stolen off of actual one-up designs. You can find it everywhere. So I think that really the only argument they could have is that arcade up there, but who knows? So it says, but I wonder if you don't want to chance it. I doubt they would go after you for the hat. Yeah, I mean, I doubt they would too. They haven't done it to anybody else, and we know other people are making similar hats and stuff. But we'll see. I do. It's funny because I do have another one. The first time through, the company messed it up. So you can see they put extra blue in there, and they made the Great Again blue. I actually kind of like the Great Again blue, but I didn't like that up blue. Otherwise, you might have seen the hat earlier. I had to wait for them to remake it. Tim says your knowledge exceeds ThinkUp's. Hey, it's interesting. Like, I really wonder who their attorney is. I mean, it's a firm. There's like 3 or 4 guys listed, but you never know, right? A lot of lawyers will take a case whether they think they have a case or not. It'd be interesting to find if it was taken on contingency. If it is a contingent case, the lawyer is going to push forward no matter what if they think they can get any money, and they're going to put big claims to try to get a settlement, right? So legitimately, like I said, I think that potentially up to $10 million that could be owed to ThinkUp is probably a legitimate claim. And so if their attorney goes, well, let's claim all this other stuff, let's make an argument that the royalties go on forever like you believe, then we can claim they owe you millions and millions upon that 10 million, and then they'll settle and give you 10 million to go away or something, and then the attorney gets half that, or whatever. So could be why they're taking it forward. Could be why they've made some of the claims they've made. Um, I don't know that. Again, it's all opinion. All of this is opinion, entertainment purposes. Uh, I'll use Ronald Reagan's litmus test. Ask yourself, is Arcade One better than it was 4 years ago? Yeah, I mean, you could. Is it better than it was 2 years ago? Let's see. I like that blue one better. I do like the blue at the bottom. I do kind of like. Surprised they don't go after the local One Up arcade and bar. Yeah, well, I think One Up, the arcade and bar, has been around longer than Arcade One Up. So you would think that One Up arcade and bar might go after them, but which is why I think it'd be really hard to prove that the trademark doesn't have prior art and wasn't established already. I mean that One Up in Denver, which has various locations in other cities, has been open for more than a decade, much longer than Arcade One Up. Make One Up great again. Well, you certainly do that. You could also just do a One Up. Got to keep the goofy MAGA, otherwise it isn't quite as funny. I'm sure the most part lawyers will go forward and then charge you $7.50 an hour. Yeah, I just don't think in this case they're probably charging ThinkUp. I think if they were, ThinkUp might not have refiled. I think this is probably a contingent case, but we're never going to know that. Kevin says it would be hilarious if they got one of those TV lawyers where you don't have to pay unless you win. Yeah, well, lots of cases are done on contingency, especially some divorce cases, right? You know, as men, we generally don't get that benefit, but lawyers that represent women often do contingent cases. The bar came first, absolutely. If your attorney is charging you 50% of whatever indemnity you receive from a court case, you need a new attorney. But again, contingencies, they're going to take a huge amount if they did their case for free, right? Arcade One Up can't afford to pay them if they end up owing ThinkUp. Yeah, so it's an interesting comment, Biggie, because there are rumors that Arcade One Up may owe money to other people. Again, pure rumors, not going to speculate on who they owe or how much they owe. But if they're having problems paying, say, a licensor, right? Do they have the money to pay ThinkUp? If ThinkUp were to get an award, probably not. And I mean, it goes to the fact that they went to ThinkUp in what they say is good faith to renegotiate the contract and continue their business relationship because they couldn't financially afford to continue paying them 3% of those net sales. Again, we need to see those books, so hopefully we'll get to see them. Stupid Fat Hobbit says, read my lips. I did not have a contractual relationship with ThinkUp. And Kevin Clausen flying in with the $2 super chat. I'm voting for James in November. Make arcades great again. 100%. Appreciate the support, Kevin. Appreciate the super chat and the endorsement. I won't let you down. Arcade One Up is lucky that Johnny Cochran. Yeah. Okay, so Thumper Squid shouting out Kevin. So I appreciate it, guys. Again, this is the third stream in less than 24 hours. So I feel like I'm the cornercade. So let's fucking go. Go vote for, go vote. Go share your support for James Hates Everything for Arcade One Up President and CEO. Get that hashtag Make Arcade One Up Great Again rolling. And until next time, have fun.